In this section I want to look at timing with respect to exclusion. For instance, if someone is granted refugee status and then subsequently it comes to light that not all the information was available to the RSD hearing, then that is a ground for revisiting the grant of refugee status and, if appropriate, excluding subsequent to refugee status having been granted. This is particularly pertinent in cases of the grant of prima facie status, where there might be a mass influx, and at those times, because refugee status is granted to several people, many people all at once, then as those individual cases are reviewed, it may be that later on refugee status that was granted on the prima facie basis has to be removed because the person falls within the exclusion clauses. That being said, what about Article 1F generally? So, someone is granted refugee status. Can subsequent crimes or acts thereby lead to exclusion? It used to be thought that Article 1F only applied to acts prior to the grant of refugee status, and that is clearly the case with Article 1FB, because that reads as follows: the provisions of this convention shall not apply to any person with respect to whom there are serious reasons for considering that B. he has committed a serious non-political crime outside the country of refuge prior to his admission to that country as a refugee. So in the case of 1FB, it's clear that the serious non-political crime must have been committed prior to the grant of refugee status. In the exclusion guidelines of 2003, UNHCR put forward that in the case of 1FA and 1FC, it may be that even once refugee status has been granted, and properly granted, that on the basis of the evidence known then, the person should have been granted refugee status, subsequent activities, the commission of a war crime, the commission of a crime against humanity, the commission of a crime against peace, or that they are guilty of acts contrary to the purpose and principles of the United Nations, that can lead to exclusion then, basically to revocation of refugee status, which is akin to Article 1.4 of the 1969 African Convention, which does call for cessation in certain circumstances, not, funnily enough, in line with the ones we've just mentioned. So if one follows the guidelines, one is forced to accept that 1FA activity crimes or 1FC acts can lead to exclusion after the grant of refugee status. A particular scenario: someone arrives in a particular country, they are granted refugee status, that is a proper grant of refugee status, then they leave that country, go abroad, commit a war crime while they are abroad, come back. At that point, following the 2003 guidelines, it would be possible to exclude them from refugee status. Prior to 2003, most people had thought that it would be Article 33.2 that would be applied in the case of someone who had been granted refugee status but then subsequently engaged in particularly serious crimes, or their presence posed a danger to the security of the country in which they had now found refuge. 33.2 and 1F are different. The approaches are different. For instance, just looking at the language, 33.2 talks of particularly serious crimes. It doesn't talk about particularly serious non-political crimes. It's particularly serious crimes in general. Or, as the first limb of Article 33.2 points out, there are reasonable grounds for regarding as a danger to the security of the country in which it is. A much broader concept, much broader even than 1FC. 33(2) also requires that if a particularly serious crime is being committed, that there's been a final conviction for that crime. So they are completely different, and it is the case that if someone had been granted refugee status, had gone abroad and committed a war crime for which they could not be prosecuted in the country in which they found refuge, and in which case they were not also seen as a danger to the community in which they were now residing, it would have been impossible to have dealt with them under either 1F or 33(2). Whether that was appropriate, don't know, but for certain, since 2003 it is clear that 1FA and 1FC can be applied post the proper grant of refugee status. In this section I want to talk about defences that might be raised during an exclusion hearing where there is some evidence that the person has been involved with war crimes, crimes against humanity, crimes against peace, serious non-political crimes, or acts contrary to the purposes and principles of the UN. It might be thought that it's strange to even talk about defences with respect, let's say, to crimes against humanity, but they exist. Starting with one that is problematic for exclusion. What do you do with the person who has a conviction for any of the relevant crimes from some time in the past? They've actually served a sentence. At what level? Okay, there are clearly serious reasons for considering that they have committed a war crime. They have been convicted and spent time in prison. But does the fact that they spent time in prison, that they have paid for their crime, as it were, mean that they should no longer be excluded? Is expiation a defence to exclusion? And what of the person who has never been convicted but who has now changed and the activities relate to things that happened 20 or 30 years ago? What do you do in those circumstances? On the face of the convention, they can be excluded, and a recent Supreme Court of Canada case, Fabulous, held that that should be the approach. Basically, there are serious reasons for considering that because they have spent time in prison, and that's enough. Personally, to my mind, that should not be the approach, but there are different practices in different countries and it has to be a country by country analysis. Moving on to duress. Should that be a defence? It's much more appropriate to think about not excluding someone who did not act of their free will. They may have committed a serious non-political crime, but if that was done on the basis of threats to their life, should they still be excluded? What of the doctor who lives in an area of a country where rebels are in charge, where the rebels undoubtedly commit crimes against humanity or war crimes? If a doctor treats that person, should they be excluded? To my mind, no, but you can see the arguments that could be put in favour of saying yes. Much more complicated is the issue of proportionality, and here we come back to the use of serious in serious non-political crime. I personally think that the arguments here can also be used in relation to some of the crimes listed in 1FA or acts in 1FC, but for the moment let's focus principally on 1FB. To be excluded under 1FB, there have to be serious reasons for considering that the person has committed a serious non-political crime. In assessing whether they should be excluded, should one take into account the consequences that they will suffer, if they are not granted refugee status, if they are sent back? Now, in Europe, for certain, and in other countries around the world, it may be possible that even if they are not granted refugee status, complementary protection under international human rights law might step in and protect them. But I am focusing here purely and simply on the case of a person whose only hope is protection through the 1951 Convention. In those circumstances, should someone who has undoubtedly committed a serious non-political crime or a 1FA crime, or guilty of a 1FC Act, should they still be excluded if the consequences for them, if the treatment they will receive on being returned to their country of nationality, be so serious that one should not deem them excluded? Is there a balancing exercise between what they did and the consequences they will face? It's already been decided that it is a serious non-political crime, for instance, but is it so serious that they should be excluded given the consequences of exclusion? I would argue proportionality should be part of refugee status determination. UNHCR equally in its guidelines talks about proportionality being an element in the exclusion process, but many countries, it has to be said, do not allow for this double balancing process. First of all, to find that the crime is serious enough that the person should be excluded, and then that it is serious enough that the consequences of being excluded should not matter. This double balancing. First of all, it's a serious non-political crime. It is that serious, but it is equally so serious that the consequences that they would face are outweighed by the seriousness of the crime. One could even talk about certain war crimes that are not grave breaches, for instance, are they sufficiently serious? But I'm going to focus on 1FP for this purpose. In those circumstances, should there be double balancing? Should a proportionality test be applied? I would say yes. UNHCR would, in certain circumstances, agree with that approach. Courts in various countries, though, have said no. There is no double balancing, and one should have regard possibly to the Court of Justice of the European Union in the German reference B and D as being possibly a clear analysis of why this is not the case. On the face of the treaty, there is no proportionality test. I would say, nevertheless, there should be. Countries have taken a different approach. In this final section, I want to talk about the consequences of exclusion. Let's assume that the person has been excluded or Article 33(2) has been applied. What happens next? It may well be that despite exclusion, the person still cannot be returned to their country of nationality because international human rights law steps in and prohibits, through complementary protection, surrender. That being said, there should be other consequences too. If one finds that a person should be excluded for having committed a war crime, is it sufficient that they are excluded from refugee status but possibly not returned to face trial because of human rights considerations? Most war crimes, since the jurisprudence of the International Criminal Tribunal for the former Yugoslavia, International Criminal Tribunal for Rwanda, can now be prosecuted under customary international law using universal jurisdiction in any state. Should the state of refuge then step in and prosecute? I would suggest yes. I would suggest indeed that in any situation where a person is excluded but cannot be returned to face trial, the state providing refuge should assume jurisdiction to prosecute. This may be complicated. This may require great resources on the part of the state of refuge. But is it appropriate that a person who has committed a crime so serious that they should be excluded from refugee status, that they should just walk around free, that effectively even non-refugee status leads to impunity? I would suggest no, and some of the reading that we set out in the materials at the end gives you further lines of inquiry on this ground. What about extradition? Extradition and exclusion we've already mentioned, but should a person who has been granted refugee status or excluded ever be extradited? Article 1A2 is no bar to extradition as long as the requesting state in the extradition hearing will protect that person, won't violate their human rights, and won't refool them if they convict them, or even if they don't convict them. So to that extent, extradition is a possibility as a means of dealing with someone who has been excluded on the basis of criminal activity. They can be sent to another state, even if the state of refuge won't prosecute, that has jurisdiction to prosecute, as long as human rights guarantees are protected, and as long as this does not lead to refoulement to the country of nationality. But extradition can be just as complicated. There are particular hurdles to be overcome in any extradition hearing. This is not a time in which to go into great detail on this. Again, there is further reading in the material set out at the end of this video, but I would suggest that extradition cannot be ignored as a means of dealing with someone who has been excluded but who still cannot be returned to their country of nationality. Those two approaches, therefore, trial in the state providing protection, state of refuge, trial in some third state which will uphold human rights and which has jurisdiction, also a possibility. This very brief introduction to exclusion, I hope, has raised many questions in the minds of those viewing it. I hope it's been sufficiently clear that you can see all the problems, even if they haven't been drawn out to their full extent. There was no way in this brief video that I could have dealt with everything. The reading list at the end, I hope, will provide you with more material. Thank you for watching this. I wish you well in all your endeavours in dealing appropriately with the question of exclusion when carrying out refugee status determination. Thank you.